The Supreme Court appears ready to limit a key part of the Voting Rights Act. During oral arguments yesterday, the court's conservative majority suggested race may have played too much of a role in the creation of a second majority black district in Louisiana. For decades, the High Court has said race can't be a predominant factor in drawing conditional district boundaries, but it has allowed states to consider race to give minority voters equal opportunity. Now this ruling could have a major impact on the balance of power in Congress. ABC's contributor and Hofstra law professor James Sample has more on that. Hi, James. So some justices seem to be questioning the legitimacy of this Louisiana district, but it's not clear if they're prepared to issue a more sweeping ruling against factoring race into redistricting in general. So what are the potential outcomes here?
Diane, this is a litigation that goes to one of the most successful pieces of legislation in American history. The idea of the Voting Rights Act, which turns 60 this year, passed in 1965. One of the sections of that Voting Rights Act, in fact, one of the only sections that is still intact after a 2013 decision, neutered really one of the main provisions that had long been successful in preventing discrimination in voting practices, particularly in states that had a history of discrimination. That was known as Section 5. The litigation at issue now is known as Section 2 of that same Voting Rights Act. And as you said, Section 2 of the Voting Rights Act allows states to draw districts that allow for what are called minority opportunity districts or majority minority districts, so that individuals and groups who have been historically the subject of discrimination in voting practices have the opportunity not only to vote, but to elect their representatives. So to your question, there are potentially two outcomes here. There's conceivably a third, but it doesn't look like the third outcome is really a realistic possibility, and that would be that Louisiana's districts are just upheld as they are. But the two possibilities are sort of a narrower decision and a broader decision. The narrower decision would strike down the second of two districts in Louisiana that is one of those opportunity districts. And the broader outcome, the more terrifying, frankly, outcome, is that this litigation could be the vehicle whereby the Supreme Court strikes down all of Section 2, which would really render the Voting Rights Act basically a dead letter.
So, James, what's the potential precedent of a case like this, and how does it then go on to impact elections in the future?
The precedent, Diane, would be that this piece of legislation, which, to be clear, was passed on a bipartisan basis in the 60s, was reauthorized during the Reagan administration on a bipartisan basis, and then was reauthorized for 25 years in 2006 when George W. Bush was the president. And the vote in the Senate, it's worth noting, in 2006 to reauthorize the Voting Rights Act for an additional 25 years, which would take you to 2031 if the court were to allow the legislation to stand. The vote in the Senate was 98-0. In the House of Representatives, there were only 33 votes against this and 389 votes for reauthorization. So the precedent would be the court striking down that piece of legislation, and the ramifications, states like Louisiana, Alabama, Georgia, Texas, and Tennessee would presumably lose all or at least most of their majority minority districts that exist now, and the partisan ramifications of what would be a redistricting free-for-all, even making what we've already seen in terms of the mid-decade redistricting that is occurring in Texas, in California, in North Carolina, it would make that look like child's play. You would have a free-for-all, and realistically, you would see a dramatic decrease in persons of color, minority groups represented in Congress.
James, why couldn't someone, if they think that redistricting is happening purposely to sort of to put black voters, for example, and limit the number of districts and where they have power, couldn't you then come to the court under the same argument and say they are using race in this way and that, per this decision, is illegal?
Yeah, I mean, there's a tension here, Diane, to be clear. There's a tension between the 14th and 15th Amendments, which ensure equal opportunity, equal protection, and give to Congress in both of those amendments. Congress is authorized in what's called the enforcement clauses of those amendments to pass legislation that serves the substantive goals of the 14th and 15th Amendment, the 15th being specifically on point with respect to vote. The question is whether they need to do so in a remedial fashion or a colorblind fashion. That's the issue that the court is now squarely deciding.
All right, James Sample, thank you. And let's bring in Deputy Director of the ACLU's Voting Rights Project, Sarah Brannon, for more. Sarah, thanks for joining us. I know you were actually in court yesterday. So what stood out to you about the arguments and the justices' reactions?
So I think what was clear yesterday is that we had, of course, it's always hard to predict, and we're not really going to know what's going to happen until we get an opinion in Calais. But yesterday we did see that the entire bench was highly engaged. The argument lasted for more than 2 hours. So certainly they were considering a lot of different issues and a lot of different factors. And we do know that the facts in the Louisiana case and the decades of the Supreme Court's precedent are on our side, including the court's ruling just 2 years ago in Allen versus Milligan, which specifically held that it is appropriate to use race when considering remedies to violations of the Voting Rights Act.
It's one thing to read the statements, the questions going back and forth in a case, and even hearing the audio, seeing expressions on people's faces, seeing the body language. Did you feel like you gleaned anything from that yesterday?
I think it's very hard to tell. I think what you could tell is that the justices have lots of different questions. There were a number of different topics that were discussed yesterday about both the constitutionality of the Voting Rights Act and about the Jingles case, which is the longstanding precedent that the court issued and reaffirmed in the Milligan case 2 years ago that addresses how exactly Section 2 is worked, both in terms of finding evidence to prove a Section 2 violation. And then there was a lot of discussion yesterday about what remedies might be appropriate if you find a Section 2 violation. But we are concerned. I think it's important to be clear that the stakes here are incredibly high. While this is a case just about Louisiana, and there is the potential for a narrow ruling that would remand this case back to Louisiana for further consideration of how to comply with the Section 2 violation that was found in Louisiana. If the court strikes down the map that was selected before, that does seem inevitable that that's likely to happen. But what happens next, we don't know. But we are very concerned because the state and many of the challengers in this case are clearly seeking a much broader ruling from the Supreme Court that Section 2 itself is unconstitutional, or a significant narrowing of how Section 2 works that would make it very hard to remedy violations of Section 2 in a way that give voters of color equal opportunities to participate in our electoral process.
All right, Sarah Brannon from the ACLU. We appreciate it, Sarah. Thank you.